thank you so much for coming. I'd like to introduce Linda Anderson. She is from Anderson Elder Law. She is a certified elder law attorney. She is one of approximately 40 certified Pennsylvania elder law attorneys, longtime member of the National Association of Elder Law Attorneys. She served as chair of the elder law section of the Pennsylvania Bar Association, vice president and director for the Pennsylvania Association for Elder Law Attorneys, and is the co-chair of the Delaware County Bar Association Elder Law Committee. And we thank her so much for being here and presenting to us. I also want to introduce Kathy Warshaw, who is from True Care Home Care Services and Sarah Care Adult Daycare Services. If anyone has any questions for Kathy after the session, please feel free, and we thank you for coming. So, this is our last presentation of the academic year, and I thank you so much for your support for our presentations that we've had, and I want to thank you, Linda, for bringing us Josh Wilkins. We had a great presentation with him. Both of his presentations were wonderful. So I'm going to turn the program over to you.
Okay.
Thank you very much.
Thank you. Thank you. All right. So inside the folder that everybody has is the PowerPoint presentation. And I'm going to follow the presentation up to the point where people start asking questions, and hopefully this is more than just a monologue. And when I prepared this presentation, this was for January 27th, I think. Does anybody remember what happened on January? That was one of the first of the snowstorms.
Yeah.
Yeah. And so the idea is to talk to the group and make sure that the content that I'm delivering is relevant to what you are working on. And so my understanding is that I'm talking to people that are sort of at the front line, that they are actually caregivers and are trying to access information and resources on how to, again, like what I referred to just a few minutes earlier, the idea of how do you deal with control issues, what are the financial issues that you can anticipate, and what are the medical issues, and what about asset protection? So knowing that I've got a whole hour, we're going to talk about all of it, and I hope we actually do talk collectively. So again, knowing that we're going to go through some material, I'm going to start with what does caregiving look like. And so for each client that comes into my office, the first consultation, which usually takes about 2 hours, is for me to figure out what kind of caregiving am I looking at, and what are the various resources that are available to help take care of this client. And there's really two predictable types of cases. One is where I've had a client with a sudden event, perhaps there was a stroke or a heart attack, and the idea is that they're going to need some acute care and then perhaps some rehab and then hopefully recover, and if not, then they may actually be what's on the continuum of care, which we'll talk about. But the idea is that there was this precipitous decline. The other type of caregiving situation is something that's more chronic, where you know it may be at the very beginning and you know there's just something not right, you don't know what it is, yet things are not working the way they should, and you're anticipating a long-term problem where there are going to be declines, and you're trying to figure out, what do I need to do? If you say get my ducks in a row, what does that mean for somebody that might have like an early diagnosis of Alzheimer's? So we're, this group may have people in either camp, but what we're going to find is that some of the transitions that you go through, whether it's an immediate acute care or a slow progression, the transitions from different levels of care tie into different sources of payment for care. And all of this is very predictable if you actually know what the resources are. So that's what we're going to cover. So we're going to talk about control, because really it's not great. It's not enough just to know about how to finance long-term care or what the different programs are, but you actually have to be talking to a decision maker when you're actually doing the elder law work. And if you're a caregiver, it really means that you have to be a surrogate decision maker. And it's very difficult when you are doing all the work when you don't actually have any authority. And if you are a caregiver, and that's usually when people laugh, and don't we all know cases where we have a parent perhaps who's actually hitting the fan, and a child on site who's pulling the heavy oar, getting all the resources together, aligning the care plan, going to the doctor's offices, finding out about Medicare, looking at all those things, only to have a sibling come in from California, second guess everything, and a friend of mine, a colleague of mine, calls those the seagull siblings. They come in, poop on everything, and then fly away. And that gets to the core, which is the very beginning of the conversation, which is control. And the idea is that when I'm an elder law attorney, I'm always representing the most vulnerable person, which is the person in many cases either a parent or a spouse or joint married couple. And so we're trying to strike a balance as an elder law attorney to hear what the client wants and recognize what their best interests are, what their goals are, but to always find that surrogate decision maker because they can't physically or mentally and many times actually implement their plans. So when you're talking to a parent, the idea is that we're trying to do a couple things. We're trying to actually get authority to take some of the burden off of them, which means we're assuming control. At the same time, we're trying to actually get them to loosen up. And many times, some parents will have never signed a financial power of attorney or a healthcare power of attorney. From the control issue, when you have a parent who's willing to let people help, the idea is that we do have to recognize that there are different points of view with different siblings. Dealing with those control issues is something that when you follow the ethical rules, I think for me becomes very easy. The idea is that I have a principal, it's the parent or the spouse, and if I have a surrogate decision maker, I'm going to want them to have authority with a financial and a medical power of attorney or a living will. If I had a whole lot of time, I would go through and figure out who needs help, sort of assuming the burden of worry for financial issues. What I'll do is just touch on some of the things in the PowerPoint slides, which let me make sure I'm caught up. Okay, so if I actually have somebody that is trying to manage the financial issues, and they have an acute case. Mom has just had a stroke, it's a single parent, and the idea is that this is a parent that has been extremely confidential about their asset information up to this point, and perhaps there's a financial power of attorney, but the child or whoever's named as the agent has no idea what to actually do. Where do you begin if you're supposed to be the the agent under the financial power of attorney? And what I'll do is just refer you to the crisis response in finances, which is you need to make a list of all of these things. Getting an asset list is one of the hardest things to actually do, and many clients are surprised when I actually put the total together and say, you have almost, $500,000, $800,000, whatever the number is. Knowing where the debts are, finding where the actual original documents are. What if you absolutely know nothing? I've had some cases where the parent had dementia and actually was busy throwing out absolutely everything, and that the child was was coming in for an appointment. Well, we got a credit report. We requested tax returns. We were able to find out who did the tax returns, and we could contact that accountant. So there's a way to reverse engineer all of this information, but the bottom line is that once you assume the burden of worry, you have to have a financial power of attorney, and then you have to actually start collecting all the information. When I think about a financial power of attorney, many times people will come in and say, well, I don't need a power of attorney, I've got it covered. My mother named me on every single bank account, so if I need to write a check, I'm good. Well, being on a bank account is not a substitute for a financial power of attorney. You absolutely have to have a general durable power of attorney that has bells and whistles. Bells and whistles vary from state to state. Pennsylvania doesn't have a statutory form. You can go to New York and we can tell you exactly what a statutory form is going to look like in New York. Pennsylvania, it's a function of what does the lawyer put into it. As an elder law attorney, I'm putting things in that are extremely powerful because my clients have had a conversation with me and have told me that if they ever lose their health, one of their stated goals is the protection of their resources for them. So we are going to have the ability in this financial power of attorney to maybe do some irrevocable trusts or perhaps make transfers of assets. And we're going to talk about that when we talk about financing. The bottom line is, though, if anyone here is a caregiver and they're assuming the burden of worry for finances and you don't have a power of attorney, you need to get one. And if you do have a power of attorney, you must look to see, does it actually have content that allows carefully planned gifts, the creation of trusts, any of the things that, I'm going to rely on as techniques for elder law work. And just a footnote for those of you who are caregivers in Pennsylvania, Pennsylvania actually is in the forefront of adult children being held liable for indigent parents. That's a whole mouthful. What did I just say and what does that mean? 2005, Pennsylvania recodified a statute that actually in most states had been abandoned, which is the statute that says adult children are liable for their parents if they become indigent. So in July of 2005, Pennsylvania said, let's go get this statute and put it right in our domestic, our family law statute. And so with this law, we have now a statutory framework for creditors to look to adult children to be liable for their parents' bills. Okay? Pennsylvania is at the lead. So if you're going to be managing finances for anyone, you're going to want a power of attorney because you want to be acting on behalf of a parent with a document that says you are an agent, and that's one way of protecting yourself as an adult child. If you're doing something as an agent and you're using the resources of the parent, I think there's a very good case to be made that you should never get to what we call Act 43 and filial liability. Okay, so the first takeaway message is if you're a financial power of attorney, make sure it's a great power of attorney and make sure you tell everybody you're an agent. Okay?
I have a quick question.
Sure.
I assume the spouse, if the spouse of the sick person is still living, that they would be liable first.
The question was, for the tape, is if we have somebody who's married, perhaps there is a spouse, and that spouse may be on as power of attorney and also married. The legal support obligation between spouses doesn't depend on whether or not there's a power of attorney, and that's correct. The spouse is going to be liable first. But in Pennsylvania, when you have unpaid nursing home bills or you have unpaid medical bills, the creditors are going to look to the adult children to see, well, did they do something? And unfortunately, our Act 43 doesn't say if you're an adult child who received a gift or if you're an adult child who did something wrong. It just says adult children can be held liable for indigent parents.
Right.
So if you're going to be doing any kind of long-term care planning, you need to make sure that your plan connects the financing to the providers so you don't have any providers looking to sue anyone.
But the spouse will be sued first, I would
The
assume.
spouse will be sued first, but if there's a child, there's a child who's potentially liable. Now, the interesting thing about Act 43, which nobody pays attention to, is that it goes up and down. So we have adult children who can be liable for indigent parents, but we have parents who can be liable for indigent children.
Oh.
So again, this could be a whole other hour on Act 43. But if you Google Act 43 and there was a great article in the Philadelphia Inquirer about 3 years ago when there was a case that came out. There was a child who was held liable for, I think it was like $82,000 or $92,000 worth of nursing home bills. It was the Pittas decision, Pittas. So if you Google Philadelphia Inquirer, Pittas decision, you can see a little bit of what I'm talking about. Okay.
Can I just clarify something? So if you're a Pennsylvania resident and in the power of attorney you're established as an agent, does that allow you to bypass this liability?
No. So the question is, if you're an agent, is that sort of like a shield to potential Act 43 liability? And the answer is no. But if you're acting as a power of attorney, the instruction is you're the decision maker. Your principal gave you authority to figure out these issues, and figuring out these issues means how do you use these resources to keep everybody paid? It doesn't mean you can't do asset protection work, but you better connect all the dots. So the idea is that you're going to have a fiduciary duty as an agent under power of attorney, and it means that you're going to have considered all of the angles. All of the angles are going to include getting creditors paid. And Act 43 is sitting over there, so whomever is the agent under power of attorney, if they didn't do a good job, all the children are lined up. So at this point, the question usually is asked is, well, I live in New Jersey. so I'm going to be okay, right? Well, potentially you could be sued no matter what state you are, but technically it's easier to sue the adult children in Pennsylvania. So now that we've got everybody's attention, we've got okay.
If attention's the word for it.
Yeah, attention and tension. Hey, the idea is make sure you get yourself a really good power of attorney and get some good advice and follow it.
Friend cards.
Yeah, I did, but you know, the idea is.
Can I just ask one more question? If grandchildren are named as power of attorney, does that protect the child? Like if you have 3 generations and because you know, as a geriatric care manager, I have a client right now where the mother has dementia. And she set up this thing where her grandchildren are named. So her daughter, who she lives with, doesn't have the power of attorney. Could she be liable? Or do the grandchildren become liable because they have power of attorney?
When you're acting as an agent under power of attorney, you're a fiduciary. You will be
Okay.
held to a high standard, and if you fail to meet that standard, you'll be sued individually for that role. The fact that there is a statute in Pennsylvania really focuses on adult children. It doesn't allow, I don't believe, adult grandchildren to have any potential liability. And if a parent dies, I don't think the generations are elevated. So again, the power of attorney isn't going to be a shield to somebody claiming Act 43. My point is that when you've got somebody who needs help, get a power of attorney and actually give them help. Don't allow planning that you know, possibly creates unpaid creditor issues, because we do have Act 43. Okay, so that's really the point for the finances. For the medical, you know, so we're talking about how to correctly assume the burden of worry for financial. That means you're going to have a power of attorney. Well, how do you correctly assume the burden of worry as a caregiver for medical decisions? Well, there's pretty much, everybody knows about HIPAA privacy regulations. And when you think about it from a healthcare provider's point of view, they're all too happy to give information or take instructions, but they are working really hard to make sure that they're talking to the appropriate person. The patient is the appropriate person, but if that person can't give what's called informed consent, and informed consent is a legal term, which is that the person has to have capacity to be able to understand the proposed treatment, the alternatives, the risks, the benefits, and that analysis, when the person goes through that process and says, I consent to the treatment, then the healthcare provider knows that they have the authority to do that procedure. And under the HIPAA privacy regulations, they're looking to make sure, are we giving this information to somebody who's authorized, whether it's the patient or somebody who's actually an authorized person under HIPAA. So if you were to design a document where you addressed those 2 issues, it would be called a healthcare power of attorney. So if you're assuming the burden of worry as a caregiver for medical issues, you're going to want a healthcare power of attorney. What's the difference between a living will and a healthcare power of attorney? Well, does everybody remember Terry Schiavo? Okay. Yeah. She could have had a healthcare power of attorney, I doubt it, but what was missing was the living will. It's also called an advance directive. And the idea is that if you have a living will, you've done your family and friends a huge favor by telling them if you are either permanently unconscious or end-stage medical condition. An end-stage medical condition used to be called terminally ill. But if you are either in either of those conditions and not able to communicate, because if you can communicate, we don't need to rely on a living will, okay? But if you're ever at end of life, the idea is that you're going to say, do you want a feeding tube if you're permanently unconscious or end-stage medical condition? Well, Terry Schiavo didn't give her family that information, so for 15 years, from age 35 on, I believe, she had a feeding tube that was pulled out, put in and out. One of my favorite living wills that I did for a client was they brought in a political cartoon that said, the client said, I'm ready to sign my living will, and on the little diagram it said, Jeb Bush is not allowed in the room. And I don't know if you remember, but Terry Schiavo's case was so controversial that there was actually legislation in Florida talking about that case. Okay. What's interesting about Pennsylvania, and this is again another interesting wrinkle for Pennsylvania, is that we really have a very conservative state. And one of the stated goals for Pennsylvania is the goal of preservation of life. And how that's interpreted in our statute is that if we have somebody who is either end-stage medical condition or permanently unconscious, If you look at what's called Act 169 that was passed in 2006, there's a protocol, an analysis for how these decisions are going to be made. So if we have somebody who failed to actually sign an agent and actually state their instructions, Pennsylvania law says, well, let's hear from the family. Do we know what they expressly wanted in terms of this feeding tube? They never said anything? Okay, can we infer what they would want from what we know about them? If we can't infer their instructions about whether they would want a feeding tube if they're permanently unconscious, the third level of review will start with a presumption that they do want a feeding tube. And a feeding tube will go in even though they're permanently unconscious. Now, if that doesn't sound like what your family member wants or what you want, it's not a problem to simply sign a healthcare power of attorney and take care of this problem. Okay, and this is another example of how when you take care of getting your documents done, you're doing your family and yourself a huge favor because you will actually keep control when you get documents done, which is the exact opposite of what most of the clients fear, which is I'm going to lose control if I sign some documents. That couldn't be further from the truth. Okay, so if you're going to assume the burden of worry for medical as a caregiver, you're going to want a healthcare power of attorney, you're going to want the HIPAA privacy regulations, and you're going to want the instructions from the family member to be really clear. Again, what if you have nothing? Well, I have a whole list of things that you're going to look for. You go to the pharmacy. Again, sometimes we have these fast-moving cases and the child is on site for the first time in months. We're going to be looking for the pharmacy information, the insurance cards, the doctor information. Hopefully we've got the healthcare power of attorney. If we don't, and it's an acute case, we do have a statute in Pennsylvania that has a pecking order as to who would actually be permitted to be a healthcare representative. And so there's a way to sort of get yourself on record as a healthcare representative and start collecting that information.
What roughly is that pecking order, just roughly?
Spouse, children, grandchildren, friends, people that know the person.
What about siblings?
They're down below under the children.
Okay.
Yeah. And unfortunately, again, Act 169, it's not a perfect case. So one of the worst possible cases as an elder law point of view is these blended families where we might have somebody who's been married a number of times and has children from a prior marriage. So let's, just as an example of how Pennsylvania law would apply, we don't have a document. Dad is in a hospital, unconscious. Doctor's looking at the family saying, I need somebody to give me informed consent. Okay. We have a spouse, second marriage, and children or child from the first. How does that apply in Pennsylvania law? Who gets a vote? Who thinks the spouse, the second spouse, should get the vote? Pull the plug or not pull the plug? Anybody think the spouse? How many think the child from the first marriage should get that vote? How many of you think you should just give them each a vote, and if there's a deadlock, nobody decides? Well, that's what our law is. Another example, if you don't like what I'm telling you, and you want to manage these problems smoothly, you're going to actually have a written healthcare power of attorney. It's not a perfect statute. The other example of not perfect with Act 169 is what if we do have a single person? You know, dad is in the hospital bed, unconscious, doctor wants instructions for informed consent, and we have 2 children. These 2 children never got along when they were 3 and 5. They never get along when they were in their 20s, and now they're really not getting along. Dad has 2 children. It's poor family planning. If he had had another child, we would have the vote of a majority. Right. But we have 2, so we have a deadlock. We have no decision maker. Okay? That is not the way to assume the burden of worry for anybody else's medical care. You really want these documents in place. Okay. I'm going to switch gears a little bit and talk about these you can read later on. There's the concept of what's called a continuum of care. So we're talking about, we sort of left control and assuming the burden of worry, and now we're talking about medical issues in elder law. And this continuum of care is very important to understand because when we talk about financing long-term care, there's a difference as to how to finance care depending on where we are. So some people will actually be at home and they may need just the littlest bit of help. Maybe it's 3 or 4 hours a day, just in the morning to get them up, get them bathed, get them fed and dressed, breakfast is there, they're queued for their first round of medication, somebody makes lunch, they leave. And that may be all that somebody needs. Then there may be somebody who, you know what, they want to stay home, but they need 24/7 care. So that's home health care. Then we have adult daycare. And adult daycare, we were just talking about this, is one of the best ways to spend money on long-term care. For, in our area, anywhere between $85 to $100 a day, you can get 8 hours of coverage. And the 8 hours of coverage is actually very holistic in terms of what's usually brought in. And I know that Kathy was talking about, the podiatrist, the OT, the PT that's there, the socialization so that we don't have somebody living in isolation for the entire day. So if I'm trying to have somebody who has their little pot of savings and I want to stretch it and they tell me they want to stay home, adult daycare on the continuum of care is actually a really good resource. Now sometimes people say, well, I don't want to go. I want to be home. Well, fine. We'll look at the budget, and when they see the difference, sometimes people will actually be willing. Sometimes home health care is so expensive because if it's 24/7, that might be $10,000 to $12,000 a month. So people will say, you know what? If I really need 24/7 care, I can't afford $10,000 to $12,000 one-on-one. What's the next level? Personal care. So about 3 or 4 years ago, when you drove by Sunrise, it used to be called Sunrise Assisted Living. Now it's called Sunrise Senior Living. Why is there a difference? Well, what happened in Pennsylvania is that Pennsylvania, along this continuum of care, we had regulations for home health care, we had regulations for nursing homes, and we had regulations for personal care. We didn't have regulations for what's called assisted living. Then Governor Rendell wanted to be able to use Medicaid, which is welfare, for not only nursing home, but drop it down to some assisted living. So we rolled out some assisted living regulations, but we don't have any real, critical mass of assisted living in Pennsylvania. Last time I checked, I think we had fewer than 10 assisted livings in Pennsylvania. So when you're driving by a Sunrise, what is that? That's personal care. So if we have somebody at home who needs 24 hours, 7-day-a-week care, they may go to personal care. They might be able to find one of those assisted livings in Pennsylvania, but you're not going to be able to find many of them. And then what's the next level? That's nursing home level. Okay? So the concept of this continuum of care. As an elder law attorney, my first meeting when I'm talking to the client and talking to the family, I will be spending some time trying to figure out where my gut tells me this person is on the continuum of care. And sometimes my concern is somebody will come in and I hear the story of the caregiving that's going on at the house, and I think, this is unbelievable how acute this care is, and boy, this is down here, and they really might belong up here in a higher level on the continuum of care. And really, how do we assess the correct level, and knowing that my job is to do what the client wants, which is always the least restrictive setting. And so the idea is to really keep them safe, but not so safe that they're, clipped to a wheelchair with an alarm, or, in a bed with being drugged. We're looking for highest quality care in the least restrictive setting, knowing that there's this continuum of care. My law firm, we actually have a geriatric care manager that's on staff. And our care coordinator has an important job, which is sometimes when I hear the stories to go out and be my eyes and ears and to figure out, okay, what are we looking at here? This is somebody who really could use a little bit more support and stay home. This is somebody who really could fit in adult daycare. This is somebody who should have been in personal care 3 years ago, and the daughter's burnt out and just needs somebody to tell her, it's okay. It's going to be fine. We're going to make a transition here. And believe me, how many times I've had the guilty children, adult children, saying, my mother is the toughest mother. My mother's never going to want to move. My mother is the one you've never seen before. And just like all of our mothers, there's a process, there's a conversation. And at the end of it, many times, they'll be quite happy. Okay, we get mom into the SNF, the skilled nursing facility, and Medicare pays for 100 days of rehab. Maximum benefit, we'll call that maintenance Medicare. So what usually happens is that at some point after day 20, the family's told, Mom's plateaued. We just don't see any more improvement. Is that right? You look at the Medicare and you're hoping for that 100-day rehab. This 100-day rehab is what gets the muscle tone back, the strength. If we want someone to return to be independent, we want them to be really pushed for their rehab, and we want 100 days. Well, there was a class action lawsuit, and the class action lawsuit was settled by the Obama administration. And the lawsuit said, let's all agree that maintenance Medicare is absolutely appropriate. Let's all agree that the law says that Medicare pays not only to improve, but to maintain someone's status. That class action lawsuit was settled. We have new training materials that have been issued to all the providers. It has not made a difference, in my opinion. Many of the providers are still going to be using the word plateau, no improvement. That's not the correct legal standard, and I want you all to push for the 100 days. Where's the resource? Center for Medicare Advocacy. A different self-help packet.
Sorry to interrupt. This is too ironic timing. My mom's Medicare rehab terminates today, and my appeal got denied.
Well, you appeal it to the next level.
Yeah,
and
you have to keep challenging the discharge.
And you write down the word JIMO, J-I-M-M-O. It was the JIMO settlement that was the class action lawsuit, okay?
See, Steve, aren't you glad you came here today?
I'm always glad I came, but today it's bingo.
Yeah,
Jimmo.
JIMO settlement. Okay.
Agent was denied. Okay.
All right, we're going to talk about, knowing that I'm running out of time, I'm going to combine a little bit of the financing with the transition issue, okay? So for Medicare, it's confusing because Medicare sounds so much like Medicaid. You know, there's a world of difference. Medicare is just insurance. You pay premiums for insurance, you have insurance coverage, and then you have to fight to get your insurance coverage. Medicaid is a welfare program. It's based on your assets and your income. And Medicaid is actually a safety net for the middle class. We're talking about financing long-term care. Okay, and the idea is that yes, there are all of these potential resources where Medicare may be paying for 100 days and Medicaid may be paying for nursing home level or home health care. Veterans benefits. I have many clients who are veterans, wartime veterans, and surviving spouses are entitled to a monthly pension if they have medical expenses that are consuming their income. This aid and attendance or improved pension is a huge benefit, and what I love about it is that it follows this person on the continuum of care. And aren't you glad now you know what a continuum of care is? Mm-hmm. So if I get somebody a check from the VA of $2,100 a month, it will follow them through personal care. So VA benefits are huge. Smart private pay. I can't tell you how many times I tell the client, you saved for a rainy day. I hate to tell you, it's raining. It is now time to access some of your savings. And if I can convince you to spend a little bit of money for 4 hours a day, 2 times a week, I'm telling you, you'll be able to stay home more. Or you can disregard my advice and not, get a little bit of help. And when things really hit the fan, then we're going to have to go to a higher level of care. But if I can set up a plan where we keep you in the least restrictive setting and actually access some of your resources or these other public benefits, doesn't that sound better? You save for a rainy day, and if it's raining, let's use some of your money for you. Okay, and that's sometimes a message that is actually not well received because many times people want to pass a legacy on and they don't want to use the money, they don't want the attention. So sometimes we have to start that process and get that going. And then we already talked about adult children as being potential liability. But I want to talk about Medicaid. Here's the PR on Medicaid. And there's no slide for this, so I'm sort of off the slide here. Medicaid, which is called Medical Assistance in Pennsylvania, there are 2 points of view. There's one point of view that says Welfare should be for the poorest of the poor. We should not have taxpayers paying for anyone in a nursing home that has resources. And the poorest of the poor will access Medicaid when and if they need it. The other point of view is, wait a minute. I'm of a generation where I saved every single penny. I never was a big spender. I worked for a company for 40 years. I had a pension. I'm now ill with Alzheimer's, and you're telling me in order for me to receive medical care, I must be impoverished and lose everything. My clients aren't millionaires trying to hide assets. My clients are the middle class trying to say, I never wanted to be on welfare, but I want to understand what the rules permit me to keep. And if you're a married couple and one of the spouses is in a nursing home, you must understand that in 2006, the lobbying that was done relating to Medicaid included some very unusual annuity provisions that will benefit the community spouse. What I'm saying directly is that if you are a spouse of someone who's in a nursing home, you must speak to somebody that does elder law to get advice as to proper planning, which may permit you to keep many of the assets. If you're a single person, what do you do? Well, unfortunately, we don't want to protect inheritances. That's not my goal. My goal is to hopefully create some kind of cushion so that when you're on Medicaid with your $2,400 of assets and your $45 of income, that there is some cushion to pay for perhaps the differential between a semi-private room and a private room, or additional therapy, or additional clothing, or a cell phone. Or I had one gentleman that wanted delivery for pizza. There are things that improve the quality of life that are not covered by Medicaid. And so for my single client cases, we're looking to try to create some kind of cushion. But Medicaid is a resource that's very understood and is right now a little bit of a political football. I'm a taxpayer. I don't want the Medicaid budget to go through the roof, but at the same time, I can show you studies that show Medicaid planning has nothing to do while Medicaid is actually a big part of our budget. And so that whatever I'm doing for our middle class really is a reflection of our failure to take care of a bigger issue, which is how do we allocate the burden of financing long-term care in the middle class? And until we solve that problem, we have this patchwork of resources through the continuum of care. Your job is now to figure out what the continuum of care is and whether we can pull Medicare, VA, Medicaid, your savings, adult children, your caregiving services. All of these resources have to sort of work on our fragmented continuum of care, and that's the job of the elder law attorney. Okay, so I think we got 2 minutes for questions.
So I just keep appealing and...
Well, you know what? That's right, because when you have somebody who has been told they've plateaued, that's not the legal standard. And there is a self-help packet that will take you through the levels of appeal, and you will be successful. The difficulty in those cases is that you have to convince the facility to continue the treatment. And then you have to go on the hook and say, I understand that if I lose this appeal that I'm going to have to pay. Okay.
I'm aware of that, but I'm also in the process of transitioning into long-term now.
Into the long-term Medicaid, yeah. So if it's not, if you're going to go right from Medicare to Medicaid, then you switch gears and you think, okay, well, I need to understand these Medicaid rules and the potential Medicaid planning that applies in that case.
Okay, should I bypass the appeal if I'm going into...
You know what? I think it's a question of what were you hoping to get out of the 100 days. If you really...
Breather.
A breather financially?
Well, always, but...
Well, no, I think I'm looking, nobody actually hires a lawyer for these types of cases. Thank goodness there's a Center for Medicare Advocacy that takes these class action lawsuits. But the idea is that most likely you would be successful on the appeal if you put the time into it. Kathy, did you want to talk a little bit about the continuum of care and how you fit into it?
Sure. What I always say to people is they don't know what they don't know. And I know you're a perfect example just with the questions really that you're asking. And I just want to answer some of your questions, because you may not be aware, but to buy in, they call it buying into a nursing home. If you're going to move into that, is that what you're looking at for your mother as the next step?
Yeah, she can't go home.
Yeah, so I mean, what she was talking about was spending down your assets. Sometimes that's what you're looking at. I had to do that with my aunt and uncle because they didn't have any children. So I had to take care of that for them and get my one aunt who had Alzheimer's, into a facility. I went and saw an elder care attorney, this was in Connecticut, and actually separated their assets. You don't have that issue. But with continuum of care, that's just one thing I wanted to say to you, that you should maybe look into that if you started looking at nursing homes. But relative to the continuum of care, there are a lot of things to think about. One of the things I think is really important is palliative care. And that's where you run into a lot of challenges with a lot of the things that you were talking about that I've seen with even medical power of attorney, and when you have advanced directives in place. Mm-hmm. Because you run into, I guess because of the law in Pennsylvania is where it really gets to be a question, is that you can bring in a parent to an emergency room and you have those things in place. And again, I've had clients who have had this problem, and the advanced directive is not being honored by the emergency room doctor. And you get yourself into a whole situation now where you have someone who probably would have, passed away easily and is at a point in life where they should have been allowed to live out what their directives were. They've now gone through hospitalization, they're in a rehab, and you have this whole thing that continues now. But to follow on to what she said also, I have just seen with people when they're trying to plan for the care of a loved one. My mother's going to be 90. It's just trying to get them used to some of what's out there, like the most cost-effective way really to take care of somebody who needs 24/7 care, if you are the caregiver and you're working, I found is what we call up and tuck service. Somebody comes in the morning, helps them get up, gives them their breakfast, dresses them, see that they're clean and all of that. Then they go to daycare during the day. Then they come home again and somebody is taking care of seeing that they eat their meal, they're in their pajamas, they're ready for bed. All the medication management is done ahead of time, so they're just getting their reminders. When they're in the daycare during the day, you can hit like 10 birds with one stone, because there are the people that come in and cut their toenails. There's a hairdresser that's there that can take care of cutting and hair. They even have bathing facilities in there too, because if they're resistant to the person in their home, sometimes somebody in the facility can help take care of that. There are RNs on staff there. They have special activities for people that have Alzheimer's and dementia. Our particular care facility works with the Alzheimer's Association, and we have a support group for Alzheimer's and dementia there. We specialize in that as well as other things also. It's really important, like you were also mentioning, is to see if you qualify for veterans aid and attendance benefits. It just really can help. Lots of times you might have your mom that's left after your dad passed away, and your dad, had what they call it boots on the ground, in World War II, or even now we have Vietnam era people that are coming up, and you can get the whole day of daycare paid for by aid and attendance benefits. Plus you can get the up and tuck at the beginning and the end of the day. So there's just these things that unless you look into them, you don't know what you're eligible for, and you really waiver too. So I know a lot of adult children that I work with, they don't want to spend their parents' money. They're feeling like guilty about it. And they're struggling, and maybe I'm talking to you about some of your experiences, like you're struggling to pay for things that mom needs, whether it's the cost of Depends, or...
I should talk a little bit about waiver.
Yeah.
Medicaid for home and community-based services is called waiver. And if we have somebody whose income for 2015 is $21.99 or less a month, we can do incredible things through getting Medicaid services in the community. So, and what I would say is that, all of these things are, completely complicated until somebody explains them to you, and then it's very straightforward. And it's just an incredible benefit, so that if you do have somebody that you're taking care of at home and their recurring income is under $21.99 a month, you might be able to look at waiver services.